All right, guys, welcome to the new episode of Who Wants to Be a Logician? All right, in this particular episode, we are going to discuss, right, beginning from question number 36 to 45. Yes, so let's go on and start with the Who Wants to Be a Logician new episode, 10 MCQs at one go. Question number 36 coming up on your screen right now. The shareholders of Ravi Limited passed a special resolution that the affairs of the company ought to be investigated. Okay. Shareholders of Ravi Limited have passed a resolution that the affairs of the company need to be investigated. The company submitted the special resolution to the CG. Okay. What do you have to say? Is it the power of CG to order an investigation? Is it the power of CG to order an investigation is mandatory? CG is not empowered to pass any order of investigation, or none of the above. 30 seconds to be precise is all you have to decide, and your time starts now. All right. End of your time limit. Tell me, is it the power of CG being discretionary power? That if a special resolution is received, I have to order an investigation. Is it mandatory requirement? Yes. A says it is discretionary. CG will decide, not that when you give a special resolution, it is the duty of the central government to start with an investigation. B says it is mandatory. C says CG is not empowered to pass an order of investigation on you. CG does not have power on you. And D says forget all the three options above. So first of all, what we need to understand before we learn or check the answer, what we need to understand is, does CG have the power to order an investigation? Yes or no? Now to know this, you need to know the basics of inspection, inquiry, investigation chapter. If you are my student, if you have attended my class, you might already be aware. If otherwise, I'll just tell you. This chapter starts from section 206, goes on to section 229. Okay, starts from 206, goes on till section 229, and over there, listen carefully, over there, when I talk about 206, 207, 208, 209, 206, 207, 208, 209, these are the four sections which talk about inspection and inquiry. And then you have from 210 to 229, which all talk about investigation. It is clearly mentioned in the law itself that inspection inquiry has to be or can be ordered by ROC. And when I talk about investigation, that is starting from 210 onwards, it has to be ordered by the central government only, which is nothing but a power delegated by the CG to the regional director. So you can use the word CG or you can use the word RD, that is regional director. Of course, central government can order investigation. Central government can also order for inquiry inspection if required. But ROC can order for inquiry inspection. ROC cannot order for investigation. Is that understood? Yes? Clear? Alright. So the answer is right in front of you. Power which is given to the central government to order an investigation is always considered to be discretionary. That is, you cannot pass an order to the central government. Central government passes an order for you. Understood? That is the question 36. I hope you understood the logic and the concept very clearly. Let's go to 37. Question 37. In a company, there is a serious apprehension of cornering the share of a company by a group of unscrupulous persons, likely to result in the change of the board of directors, which may be prejudicial to the public interest. Okay. The company seeks your opinion as to how it can impose restrictions on the transferability of the shares of the company, considering the provisions of the Companies Act 2013. So here they are asking a question to you. Read the inspection, inquiry, investigation section very properly and tell me, is it a possibility there transferability of the shares can be restricted by any means in a company? Is it a possibility? Yes, no. 4 options given to you on the screen. 30 seconds. Time starts now. All right. Time's up. Tell me, is it possible? Yes. If yes, which section? The answer is A. Application can be made to the tribunal under section 222 for the imposition of restrictions on securities. There is a clear-cut section 222 which talks about imposing restrictions on securities. Okay. The previous section talks about properties and 22 talks about securities. So they are connected sections, one below the other. So there should not be a point of confusion over here. All right. Let's go on to question 38. Right on our screen. Here it is. After the perusal of the inspector's report, it appears to the central government that the company is liable to be wound up. After the perusal means after referring to the report of the inspector would come for inspection. It is CG feels, it appears to CG that there is company is liable to be wound up. Winding up should be done. It may cause to be presented to the tribunal. It may cause to be presented to the tribunal. What are the options? A. Petition for winding up of the company on the ground that it is just and equitable that it should be wound up. What are the options? You understand? We are saying if it is supposed to be put up in front of the tribunal, what reasons would you give? A, B, C, or none of the above? All right. Why should I read all of them? You can read them on your own. Can't you? Yes? Do it quickly. Then we proceed to the next one. 30 seconds starts now. Time's up. Tell me, would you make an application to the tribunal? Of course, we have to make an application to the tribunal. We have no other choice because the order of winding up is passed by the court or the tribunal only. Now, here they are saying, what type of application would you make to the tribunal? That it is just and equitable that the company should be wound up? Or it is just and equitable that the company should be restructured? Or it is just and equitable that the company should be merged? Or none of the above? Well, sir, the question is very clear. When CG is of the opinion that a company is liable to be wound up, the petition for winding up to the of the company on the ground that it is just and equitable to be wound up should be passed by the tribunal. So petition should be filed by the tribunal and such an order shall be given by the tribunal confirming the opinion of the central government. Is that clear? So that is again section 38 done. Go to 39 in front of you now. 39. Registrar has issued a written notice to Miss Neha, who is an ex-employee of Himalaya Limited. All right, Miss Neha. So registrar demands some information, some explanation from Miss Neha. Miss Neha is an ex-employee. Registrar says, I want some information, I want some explanation, I want some documents, Miss Neha. Miss Neha says, sir, I am an ex-employee, and she ignores the notice considering that I am ex-employee. So you have to choose the correct option. Is she liable to disclose, or she is not liable to disclose, or company is liable to disclose, or none of the above? Check it out for yourself. Yes. See, answers, questions cannot be simpler than this, I think, right? You know the answer, but still 30 seconds is what I must give you, and your time starts now. Time up. So, sir, what is your opinion? What's my opinion? There is no point of giving any opinion, right? If the ROC is demanding something from you, you cooperate with the ROC and give ROC whatever they are demanding from you. Do you have a choice over there? No, sir. Do you need a choice over there? Absolutely no, sir. Yes? So the correct answer is A. He is liable to provide whatever the ROC demands. Is that clear? Everybody? All right. Let's go on to the next question. That is question number 40. On the screen right now, offenses are covered under section 447 of the Act shall be cognizable. Cognizable means non-bailable. Non-bailable means more serious offense where even warrant is not required. How serious the offense is. These offenses which are covered under 447, they are saying such offenses are cognizable offense, and no person who is accused of such offenses shall be released on bail because they are cognizable, meaning non-bailable offenses. Non-bailable, non-compoundable, very serious offenses. However, you are convicted of a cognizable offense by the court of law, which is a non-bailable offense, a non-compoundable offense. Your bail is not granted, is the provision. And you know that. Yes, my student, you know that for every provision in law, sir, there is always an exception. There is always an exception. Here also exceptions are there where even if it is a cognizable offense, even if it is a non-available offense, even if it is a non-compoundable offense, even if it is a more serious offense, still bail may be granted. Still the bail may be granted. Under which case? A, B, C, or D? Yes? The choice is yours. Select wisely, select quickly. You've got 30 seconds. Time's up. And my dear boys and girls and everyone, the time is up. Tell me, A, B, C, or D? Well, sir, answer has to be the same answer we have done in the chapter of money laundering also. If you have done, I don't know whether you have studied money laundering or not. Same provision is there in money laundering also. Same provision is there in multiple other laws also, where even if the offense is cognizable, that is non-bailable, these are few cases where always bail may be granted if you prove that you are falling in any of these exceptions, and if the prosecutor does not have any objection. If he has objection, he will be given an opportunity of being heard. If he proves why bail should not be granted to you, then the tribunal may dismiss your appeal to bail. Otherwise, bail may be granted in such cases. That clear? All right, let's go to question 41. On your screen right now, Mr. Sharma is a KMP of XYZ Limited. He retired on 12th of May 2018. An examination of the final accounts of the company for the year ended 31st March 2018 was done. And the registrar of companies found there are some irregularities, some discrepancies in the journal entries, writing off of the expenses, huge amounts which have been written off as bad debts. Okay, that is normal course of business. I mean, bad debts and everything keep on happening if you're running a business, if you're running a company. But the problem over here was logical, appropriate explanation for writing of the bad debts was not given. In such a situation, the ROC wants some explanation from the company and from Mr. Sharma. But sir, Mr. Sharma has retired from the company. So the question is, can ROC seek explanation from Mr. Sharma? Yes or no? Advice. Sir, didn't we do such a type of a question, Miss Neha, ex-employee, just some time back? Well. Your presence of mind will help you to solve the answer even more quickly. But still, I must give you 30 seconds. And here you are. Your 30 seconds start now. Hands up. So tell me, what is your opinion? Can you call Mr. Sharma? Can ROC call Mr. Sharma? Demand information, explanation, documents from Mr. ROC? Should Mr. ROC cooperate? Yes or no? Of course, sir, we have to. Also, Mr. Sharma can be called upon by the ROC through a written notice. And there is no time limit requirement for that. Whenever the ROC feels it appropriate, his presence is required, ROC can summon him. That clear? So very simple one. Let's go to 42 without wasting any time. This is a group of creditors of X Limited who is making a complaint to the ROC. They asserted that the management of the company is indulged into destruction and falsification of the accounting records of the company. So this is a big blame. This is a big blame by the group of creditors of X Limited, that the management is involved in falsification, destruction of the accounting records. The complainants, that is the creditors, have made a request to the ROC to take immediate steps. To take what? Immediate steps to stop the company, that is company's management, from tampering with the records. The complaint was received in the morning of the 1st of January 2019 is what they say. And the ROC entered the premises within 30 minutes for search, within half an hour for the search. The course of action that can be taken by the registrar are first, second, third, fourth. What you have to tell me. Can the registrar enter the premises at any point of time? Can the registrar enter the premises before the sunrise or after the sunset? Does the registrar require any particular specific permission, any authorization to enter into premises for search? Can he enter into any other premises for search? Well, all these answers are given in the section itself. If you have read the section, everything is from the chapter inspection, inquiry, investigation only going on. So yes, if you have read the chapter thoroughly, you will be able to answer all these questions very confidently. I give you 30 seconds. Question I have already dictated to you. Answer is in front of you. Make a note of it. Read it down. 30 seconds for you. Time starts. Time's up. Tell me, is it possible for ROC? Yes, sir, it is possible. But condition is only after obtaining an order from the special court. Only after obtaining an order from the special court, ROC may enter and search the place where the books and papers are kept. And then there is no problem. All kind of search can be made with the permission. Even seizure can be made. They can take assistance, that is police also, for their assistance, for their safety. So all the provisions are there given in the law itself. Clear? Let's go to question 43. Super quick. On the screen, Raman. Mr. Raman is an inspector under 212 of the Companies Act. Okay. He's talking about what? He's talking about Serious Fraud Investigation Officer. They are saying he investigates in the affairs of X Limited, and during the process of investigation, Mr. Raman has evidenced some relevant facts and information regarding the transactions made by the company X Limited with its subsidiary Y Limited. So there are some transactions between X Limited and Y Limited which have come in the hands of Mr. Raman, an inspector under section 212, that is Serious Fraud Investigation Office. During the course of investigation, Mr. Raman required, I want to go and investigate subsidiary also, that is Y Limited also. What you have to say here as a chartered accountant is whether Mr. Raman can proceed with the investigations of the subsidiary company also or not. Go through section 212, go through it excuse me, thoroughly, properly, and then give me your answer. 30 seconds. Time's up, everybody. All right. Now, tell me, is it possible? Can Mr. Raman visit Y Limited, that is a subsidiary company? Yes or no? Sir, section 212. Did you read? Yes, sir. If you have read section 212, your answer has to be very, very simple over here. That yes, sir. Of course, he is allowed, but only after the approval of central. So prior approval of CG is required because investigation is going on, and for investigation purpose, you need central government's approval, that is regional director's approval. And once you have got that, there should not be any issues, any problems in proceeding further with the investigation. Is that clear, everybody? Yes. 43, 2 more to go. I told you the bar will rise, but next question I tell you, it's super easy. 44. Super easy, super easy. They are saying Ultra Limited is a public company incorporated on 13th May 2019. After 1 year of the incorporation, shareholders of the company came to know that some transactions inside the company are not in accordance with the provisions of the Companies Act 2013. They are prejudicial to the interest of the public. I'll tell you what they want to ask. They are saying that, is it possible that the shareholders can make an application to the central government to start with inspection or inquiry or investigation? Is it possible? Do the shareholders have the power to make an application to the central government to start with inspection, inquiry, or investigation as per Companies Act 2013? Yes or no? Tell me yes or no. Sir, did we do this before? Of course, we have done this same type of a question before, where we had to decide whether the power of CG, when a special resolution is passed by shareholders, that time a power of CG is discretionary or mandatory. Yes or no? Did we say it is discretionary? Just a couple or maybe 3 MCQs back, we discussed this type of an MCQ. Just the words are here and there. And you tell me, do the shareholders have the power to make an application to CG to start an investigation? Yes. Which resolution is required? Of course, you know all that, but still I'll give you 30 seconds to select one of the correct options. The time starts now. time's up, time's up. Time's up, boys and girls. Tell me, what's the correct answer? Is it possible? Can the shareholders make an application? Yes? No? Yes? Which resolution is required to be passed? Yes, that is, shareholders can make an application and a special resolution is required to be passed. Shareholders can make an application and the special resolution is required to be passed, and that is the correct answer. That is the correct answer. Absolutely right. You were also absolutely right. I know you all selected the correct answer only. Here also, if you did not select correct answer, no Baba. Oh, God bless you, my dear. God bless you. This cannot become more easier than this. It is a repetitive nature of a question which has come over here. Challenge yourself. Push your limits. Buck up. You don't have much time, and stop wasting time and start revising and keep revising and keep revising and keep revising. Don't get tired of revising. It's a matter of couple of months, maybe 3. Don't get tired of revising. You revise for this 2-3 months as much as you can, as many times as you can, and then don't touch those books for the rest of your life. It's a good deal. It's a good deal. Why not? Instead of touching the same books or maybe updated books every 6 months, why not give the best shot for a couple of months, maybe 3, and then never touch them again? I mean, it's a win-win situation. Do you agree? Yes? Let's go on to question 45. On the screen right now. Central government has appointed Mr. Rishikesh as an inspector to conduct an investigation in the affairs of overtaking. Okay. During the investigation, Rishikesh found out that there was some employee, Mr. Gopal, at a higher designation, senior employee of the company. What the company has done, within a few days after the start of investigation, the company has reduced his position. Position of Mr. Gopal has been reduced. Company did not try to obtain any approval from the tribunal for that. Company thinks it's my employee and my company, and we want to reduce his rank. We want to reduce his rank. We will reduce the rank. What you have to do, what you have to tell me is, Mr. Gopal says that, is it allowed for the company to reduce the rank of any employee pending investigation? When the investigation process is not yet over, investigation process is still pending, is it allowed, is it possible to reduce any ranks? Yes or no? Help Mr. Gopal, my dear chartered accountant, or my dear CA aspirants. Yes? Help Mr. Gopal to find out, is it possible or no? Choices are A, B, C, D. Yes, yes, no, yes. You tell me correct answer in 30 seconds. Time's up. My dear CA aspirants, tell me, yes, no, yes. Is it possible or not possible? Sir, we have done the chapter of inspection, inquiry, investigation very, very properly, sir. And because we have done the chapter very, very properly, sir, we know that it is not possible to reduce the rank of any employee. Reduce the rank of any employee during the investigation process unless and until prior approval of the tribunal is obtained. So, during the investigation is pending, during the pending investigation, reduction in the rank of any employee is absolutely unacceptable unless the prior approval of the tribunal has been obtained. Fantastic. So that is your MCQ number 45. And I guess we should stop here in this episode. I hope you are enjoying these episodes. This was episode number 5, which I brought to you of your MCQs discussion. I hope I am helping you to clear the concepts. If yes, well, keep me and my family in your blessings, in your prayers. You all are always there in my prayers. This is KACHALIA signing off, and see you in the next episode. Thank you very much. Thank you.